Good morning, everybody. Welcome again to another session, another employment law Q&A. My name is Chris Justice. I'm an associate with Samfiru Tumarkin, and I operate out of the Toronto offices. As always, get all your questions in that you can, and I'll do my best to answer as many of them as I possibly can. I see we've already got a couple questions in, so I'll definitely be getting to those. Before I, however, get into some of everyone's questions, as I normally do, I like to start off with a couple general topics, sometimes from my own personal experiences, other times from some of the news stories that have come out. And today I'm going to start with sort of a continuing news story involving Freshie, which many of you may know is a fast food, sort of a healthy version, I guess, of a fast food franchise that's come under some criticism for its use of virtual cashiers and essentially its way of possibly getting around minimum wage laws here in Ontario by employing individuals outside of the country. And in Freshie's situation, as I understand, their virtual cashier system uses some employees or some individuals work out of Nicaragua. So essentially, what happens is you'll go into a particular Freshie store, you'll look to check out, you go to the cashier, there'll be a virtual cashier in front of you on a screen. This person's from Nicaragua, and they're essentially there to assist with any questions you have with the cashier system or the checkout system. But as I mentioned before, Freshie is able to essentially employ individuals in a different country with different sets of laws regarding employment and not necessarily have to pay them the wages that they would earn if they were physically in this province of Ontario. And as I say, that was getting and has been getting a lot of flack from a number of individuals wondering if these are legal hiring practices. Essentially, if the employer in this case can outsource its workforce, and again, not necessarily pay the employees what they would have received had they been in this province or in Toronto, for example. And the short answer to the question is yes, companies can do this. We see this with call centers, for example, telephone communication type businesses having call centers, outsourcing the call centers to various countries in the world, let alone within North America itself. So this has been going on for some time, and Freshie is just the latest, albeit the Freshie situation is a bit interesting because there's an actual video of someone there as opposed to having it just be done over the phone. But the long and short of it is that this is above board and this is a legal practice. Now, as far as how somebody's employment can be affected by these things is concerned, many of you may be in positions where there's outsourcing happening. And you may be wondering, what happens if I lose my job because my company is outsourcing what I do to a different country in the world? And normally, just like any termination, if you do lose your job, you're going to be owed severance. And you're definitely going to want to consider the package that's offered to you if that happens. And definitely speak with a lawyer before signing anything, because 99% of the time, if you've been let go from your job and you're owed severance, whatever your employer is offering you in the first instance is in all likelihood not going to be anywhere near what you could get. So that's just one of the reasons why anytime you're offered a severance package, you give us a shout, you contact us, we set up a time to chat, and we basically go through whether or not what you received was fair and reasonable. And so the same thing would apply for anyone who loses their job due to outsourcing. There's another situation that can arise where your company tells you that they're going to be outsourcing your job, let's say to India, and they want you to train your eventual replacement. So they want you to teach or coach these employees who are now outside of the country to essentially do your role, so that when you leave, there's no hiccups there. And a lot of people definitely feel a certain type of way when it comes to training their eventual replacements. In some cases, they're obligated to train their replacements. In other cases, being asked or being forced to train your replacement could actually constitute a termination. So it's going to come down to the facts of your particular case, but that's something else that we often see when it comes to outsourcing is, being asked to train your replacement, which not a lot of people are open to doing. But before you quit or say no to your employer or refuse to do that, you definitely, again, want to get in touch with us so that you're not doing or saying anything that can, potentially affect you negatively down the road. So that was going to be my piece, at least as far as the Freshie story is concerned. I may get into some other stories that are in the news of recent note that have to do with employment law issues. But right now, just because I see a lot of questions coming in, I'm going to start to get to some of everyone's questions here. So I'll start with AJ on YouTube. And AJ is saying that even though they have a work from home arrangement before the pandemic started, their employer is threatening to suspend them without pay about 8 weeks from now. Can I treat this as a termination on the first day of my suspension? That's the question. And then there's a follow-up question regarding the odds of getting both severance and EI. So AJ, first I'll talk about the first question. I would probably need a bit more information, but if you have a contract, say, for example, that says you are able to work from home, for a certain period of time, maybe 100% of the time, and your employer is coming to you and saying they don't want you working from home anymore and they want you to come into the office. And if you don't come into the office, they're going to suspend you without pay. That may be something along the lines of what you're mentioning, AJ. So it'll depend on sort of the terms of your employment. If you're an employee who never worked from home and only recently, as of the pandemic, started working from home, even if you can do your job from home, it doesn't necessarily mean that you can force your employer to have you stay working from home. Now, if you worked from home before the pandemic, as you've pointed out, AJ, then it could be a bit different. You may have, or there may be a term of your employment at that point that says you can do your job from home and that you're expected to work from home. If that's the case, then, as I say, your employer would be coming to you and essentially breaching the terms of your employment, what you agreed to, the ability to work from home. So it's going to depend on, as I mentioned, whether there's something in a contract that talks about your ability to work from home, AJ. It may depend on sort of how long you've been working from home before the pandemic. But, so there could be circumstances where your employer is allowed to call you back and then other circumstances where they're not. Normally, in a lot of cases, a suspension without pay is definitely no light action to take on behalf of your employer. And stopping paying you could definitely amount to a termination, and you could treat day one of that suspension as your effective termination date or thereabouts. You may, though, not want to wait until that suspension happens. And I suggest you get in touch with our firm so that you can formulate a plan of action, come up with a strategy while this suspension is going on, rather than wait till the very end. I wouldn't suggest you wait. I think it's better to take initiative now. And also just to find out, what your options are, how much of a leg you have to stand on, what severance you would be owed if you are owed severance, because that's going to depend on how long you've been there, what kind of role you had, whether you find a job in the future, etc. So I think there's a lot of considerations, AJ, to be taken into account in your case, and it definitely could be the case that you are owed potentially a significant amount of severance. But without a little bit more information, it's just tough to say. But get in touch with us, and I think we should be able to help. AJ, you also ask about severance and EI, and what are the odds of getting both? And I'm going to just answer this more generally. So generally speaking, when somebody is terminated from their job and they're given a severance package, they'll be given a severance package for a certain amount of time. Could be a month, 2 months, a year, 2 years. Because that person will be getting income over that period of time from their former employer who let them go, and because EI benefits are designed to replace lost income, in a lot of cases, it's not possible or very difficult to collect both full EI and full severance for the same period of time if there's sort of an overlap. Now, there are scenarios, especially with COVID going on, where individuals who do collect severance but also receive EI can actually keep both. There have been some changes to the legislation regarding EI, and again, with sort of the context of the pandemic going on, But there are some occasions nowadays and of recent times where people can collect both, which is a bit unusual. But normally before the pandemic, there's generally no double dipping, so to speak. So that hopefully answers your question more generally, AJ. And then it just depends also on why you lost your job. So if you've lost your job for an act of theft, let's say, then it's going to be very difficult for you to get EI. If you quit your job, it's going to be very difficult, if not impossible, for you to get EI. If you are let go or you lose your job for some reason based on not complying with your company's COVID policy, as I understand, there's a bit of a challenge in getting EI in those cases too. That could apply to a termination for noncompliance with COVID. That could apply to a suspension for noncompliance of COVID. And it may not even be necessarily legally speaking above board. But if the loss of your employment or the stopping of your wages is due to not complying with a vaccine policy, just know that you may face a bit of an uphill battle in collecting EI. And that's just based on the clients that I have and the people I've spoken to who are in those situations. And my advice to those people is to just keep fighting for the EI. If you get denied EI in the first instance or at the first stage, you're going to have an ability to appeal that decision and go up to the next stage. So all I think you can really do is appeal it, fight it for as long as you can. At some point, EI or those governing EI are going to have to make a decision as to what to do in your case. And at that point, there's nothing more you can do. But I would suggest at least fighting it and hoping that you do get those benefits. But anything else, AJ, give us a call and we'll be happy to help out. I've got another question in here from Keith Smith on YouTube, who's asking, what is an arbitration status conference in a wrongful termination case? So Keith, thank you first of all for your question. When you mention the word arbitration, it seems to me like you're talking about a unionized matter. Like perhaps you filed a grievance through your union looking for severance potentially, and you've sort of proceeded along the process, and now you're at a point where maybe you're reaching an arbitration. What I will say is that I don't practice unionized matters, so I'm not all that familiar. If in fact you are asking about a unionized, particular unionized context. But from the sounds of it, an arbitration status conference might be a conference or a gathering that's held between two sides in a dispute that is just looking to confirm maybe the date of the arbitration, which would be a point where you could potentially settle your matter, or maybe the process itself of the arbitration, who's going to be involved, how long it's going to be. So if it's a unionized context, Keith, I would say definitely touch base with your local union rep and maybe also refer to the collective bargaining agreement. Otherwise, it seems like you're involved in some sort of legal process. So I would just say get in touch with maybe one of the legal experts that's perhaps working on this case of yours. But hopefully that gives you some idea. Thanks again, Keith, for your question. Stephen Anderson's asking on YouTube, regarding the manner of dismissal, what do you need to prove? So, Stephen, without more information, it's hard for me to know what exactly you're asking about, but perhaps what you're talking about is in order for someone to prove that they were dismissed in maybe a bad faith manner, what do they need to prove? So there are definitely circumstances where not only is someone entitled to severance because they've lost their job, but they're also potentially entitled to extra damages, extra compensation for the way in which they lost their job. And these situations, to be fair, are quite rare where this type of a compensation package is awarded on top of your severance. But there are definitely scenarios where an employer can terminate someone's employment rather in a very bad faith manner. For example, parading the employee around the office on their way out, or making sort of an announcement within earshot of everyone in a way to perhaps humiliate the employee on their way out. Not paying an employee compensation or severance that they're owed by law on their way out. Of course, any kind of breach of the law as far as severance or termination is concerned would arguably be bad faith. If you're let go based on a disability, based on the color of your skin, based on any number of grounds that are protected under human rights legislation, that would be a definite argument for bad faith manner of dismissal. So, Stephen, your question is a bit broad, so it'll really depend on why you believe your employment was terminated in a bad faith manner. And then from that, you would have to obviously try to prove it as best you can, whether there's email correspondence or things in writing that would support your belief that you were terminated in bad faith, whether you have witnesses that would testify potentially to the way in which you were terminated. Normally, it can be somewhat of a challenge to prove bad faith if there aren't any pieces of evidence in writing and it's just down to your word versus theirs. But it also doesn't mean that you should just dismiss any claim for a bad faith type manner of dismissal for that reason. It's just a bit more challenging. So hopefully I've answered, generally speaking, your question, Stephen. But if you had any more further questions, happy to set up a consultation. We can go through in more detail what a bad faith manner of dismissal would constitute, how that would look in terms of compensation owed your way, what your options are generally if you believe a dismissal is coming on down the line that you feel will be in bad faith. And like I say, we'll be happy to help. But thanks for your question, Stephen. I appreciate it very much. I've got another question in from Barbara on Facebook. Barbara is saying that a year ago, her company told everyone that they were going to move to working remote for 95% of the time. So that's a very common thing nowadays, or at least more common, companies switching to remote work. But now, Barbara, you're saying that your company has decided to go back on this, but you've already moved and cannot logically come in weekly anymore. Okay, so you've essentially relied on a representation from your employer that remote work was going to be done, and so you governed your life accordingly, and you moved, and now they're kind of reneging on it, and you're in a bit of a bind, so to speak. And you're asking whether or not the employer can do this. So, Barbara, it'll depend in some sense on how the employer told everyone that they were moving to a 95% remote from work arrangement. Whether it was something that was definite and concrete and set in stone, so to speak, or whether it was just an employer sort of floating out some ideas, whether the employer actually had any direct communication with you as far as this plan, whether you may have told the employer that you were moving or you were going to move or you have moved. So I think if they had knowledge of you moving based on that and they reneged, that could be a different scenario as well. So there's definitely a possibility, Barbara, that you could sort of argue that you relied on the representation of the employer to your detriment, and sort of the phrase detrimental reliance comes up. And if you can prove that you were sort of told something very clear cut, you relied on that representation, your employer was aware of maybe the efforts you were going to go through to move, and especially if now as a result you're going to suffer losses into the future, lost income, lost ability to work, there can definitely be a case there, and it could definitely be very significant. But again, I think it's just going to come down to some of those more defined issues or factors that I mentioned. But that's definitely a situation you want to call us on, Barbara, because I think it deserves a more fulsome consultation, so that you can sort of decide what your options are, whether you can simply refuse it and insist that they have you work from home going forward, or whether that's not an option. But you want to give us a shout, contact us online or through the phone, and we'll definitely take it from there. But thanks for your question, Barbara. I think it's an important one, because nowadays I can see a lot of people being in that type of a scenario. Hopefully employers aren't going back on their word. I've got another question in from Lou on YouTube, stating that they're non-unionized, they're on a leave of absence because they're not vaxxed, but they were approved for EI benefits. So first of all, that's good to hear. As I mentioned earlier on today, I found it from my experience, having talked to a number of people, that it was quite rare, if impossible, for those who did not comply with a vaccine policy to actually get EI benefits. So it's good that you've been approved for EI benefits, and hopefully that's a sign of things to come for those who are also looking to get those benefits. But Lou's asking whether or not they can whether being on EI can help get severance or if it would make it more difficult. And the further question is it better to wait until EI benefits are over? So I mentioned this earlier, but if somebody collects EI benefits for a certain period of time, and then they get severance from their former employer for the same period of time or for an overlapping period of time, then there is the possibility that the benefits, or at least a portion of the severance that you got from your employer, would have to be repaid back to EI or to Service Canada. I mentioned as well earlier that there's a little bit of an exception going on due to COVID, where it's possible for you to get both EI and severance at the same time. So I definitely wouldn't suggest necessarily that people do not apply for EI. I think it's generally speaking in their interest to apply for EI and receive their EI. It could, as I say, have an effect on how much severance they can get. But the question is going to be, do you want to hold off on collecting EI in hopes that your battle for more severance turns out to be successful? So it's going to be a bit tricky. But I would say because of the exceptions going on right now, I would probably tell most people to apply for EI, and if they're entitled to severance, then to pursue that as well. So I wouldn't think right now, Lou, it's better to wait until the benefits are over. The other thing people have to understand is that if you've lost your job and you're getting EI benefits and you're also looking for more severance from the employer who terminated you, there's going to be a general obligation on you to go out and look for another job. And normally that's a requirement, or at least an expectation, in order to get EI benefits as well, is to give reasonable efforts to try and find another job. So that's one thing I just want to mention. Lou, you didn't mention it specifically, but just that you need to generally be giving reasonable efforts to look for work, whether you're getting EI or not. And I've seen it a lot happen where people are getting EI benefits, and because they're getting EI benefits for 3, 4, 5, 6 months, they don't really bother looking for a job. They don't really take any steps to look for work because they don't necessarily need the money right at that point due to those EI benefits. And then they later on contact me to try to get more severance since the date of their termination. But because they didn't really give any effort whatsoever to look for any job, let's say for the first 6 months after they're let go, then that could potentially affect how much severance they could get. So I suppose in a way, the EI benefits are sort of related directly or indirectly. But again, going back to your question, Lou, I'd say to apply for EI right now. And if you think you're also owed severance or potentially owed severance, get in touch with us and we can kind of talk you through how any kind of an overlap would work, or whether there's a good amount of merit to your case and whether you should go after severance, because that has happened a lot. People getting both EI benefits and severance. So don't think that because you're getting those benefits, you have less of a case necessarily. But thanks for your question, as always. We've got another question in from Zuzuna on YouTube. She's asking, a customer forgot his phone at our place of employment. The phone disappeared, and now the boss is asking everyone to put some money towards a new phone for the customer. Is this legal? Thank you. So that's a good question. It's a unique question. I don't think I've ever encountered something like that before. But from the sounds of it, no, I don't see how your employer can take money or force you to pay money towards a lost phone for a customer, especially if you had nothing to do with the customer losing their phone. So I would say, while it may be a kind gesture to help chip in for the lost phone, I don't see, legally speaking, how your employer can force you or obligate you in any way to pay for that phone. And if you are getting pressured or you feel as though you're being forced to take money out of your paycheck to pay for the lost phone of a customer, I would say give us a call, because you may have more options than you think. But hopefully it's just something your employer's asking as a more of a good faith gesture. But you're completely within your rights to say no to that. And like I say, if you have any issues, give us a shout. I'd be happy to chat further or get someone else that can help you with that situation. Going through questions. Thanks again, everyone, for all these questions. I've got a question from Stephen Anderson. And actually, this is a follow-up from an earlier question about the way in which someone loses their job, the manner of dismissal, and what needs to be proven in that case. Stephen Anderson is saying, well, what if they lie? What if my employer lies about the reason for why I was let go? What if they make statements? What if they get witnesses on the stand potentially to sign a statement saying that they let you go for, this reason, which is, let's say good faith. And then you strongly believe that, that reason's a lie and that they actually let you go for a bad faith reason. The thing is, Stephen, is if they lie, it's going to be a question of, can you catch them in that lie? Because if they lie in some way, or they make a statement in writing that is false, and then you have evidence to support the contrary of that, then their credibility is going to be gone right there. If they lie in the course of litigation, in the course of a lawsuit, and they lie to the courts, and they get caught on that lie, then that's going to be a huge issue for them. Not only are they going to have to pay you severance, but they'll also have to pay you bad faith damages for that lie. And that's not going to be something looked at lightly by a court. But the question goes back to what I was saying before, is how do you prove that they're lying? If you, let's say, for example, believe that you were let go for reasons relating to race, and they say that you were let go because they needed to cut costs, the business wasn't doing well, and they have evidence to support that their financials aren't great, and all you have to support your position is perhaps a discussion that was had, it's going to come down to a credibility contest. And unfortunately, the judge in that case would have to decide who's telling the truth and who's lying. And so it'll just come down to whether you can get them contradicting themselves, or if it's really just going to be a battle of your word versus theirs, and therefore go back to that credibility contest. So it can be very difficult, these types of claims, and you definitely want to make sure that, even though you may know what the truth is, that your case, like from an evidence standpoint, is still fairly strong, especially if you're going to be in it for the long haul. But Stephen, again, that may be something to kind of flesh out in a bit more detail through an actual fulsome consultation, which we can definitely help you out with, because we're certainly no stranger to scenarios where employers lie to support their narrative, when in fact the reality is a completely different narrative. It's just going to come back to that evidentiary type information, and kind of how much of a case you can build knowing that they're going to say those lies. But thanks for the follow-up, Stephen. I've got a question in from Alex on Facebook, who's asking, does an employer have to pay out severance if they let you go before the end of a 15-month working termination notice? So first of all, I just want to quickly touch on the idea of working notice. So a lot of times when somebody loses their job, they are terminated effective immediately. On a Monday, they get a letter that says your job's over as of the end of today. Here's the severance we're willing to give you. And it becomes a question of whether that severance is enough, whether that payment, that sort of, sometimes it's a lump sum payment, sometimes it's ongoing payments, but whether that's enough. The companies don't necessarily have to terminate you effective immediately. They can actually say to somebody, we're going to terminate you, but it's not going to be for a year from now, or maybe 15 months from now. And they're within their rights to do that. Now, even if they give you 15 months, even if they give you 300 months of working notice, you still may be entitled to a severance payment, a chunk of money essentially, on top of that working notice period, no matter how long it is. In a lot of cases, there's a certain amount of money that cannot be satisfied by way of working notice. So the employer, while they may want to do the entire thing by way of working notice, they actually can't. If an employer in your situation, Alex, lets you go before the end of a 15-month working notice period, then that just means that they won't be able to take credit for those remaining months. So if you lose your job, let's say 5 months into a 15-month working notice period, but your employer still owes you those other 10 months, then they may not necessarily have to have you work out those 10 months, but you're going to probably stand a good chance of pushing to get those 10 months paid one way or another. And so if they cut your working notice period early and you're still owed that extra 10 months, then it may be a question, Alex, of you now asking that employer or insisting that employer pay you out for those 10 months and give you essentially 10 months worth of your wages in one payment or perhaps installments of payments. So they could technically let you go before that, but that's not going to necessarily change how much money or how much severance they owe you in total. And it just means they're not going to be able to take credit for as many of those months if they cut it short. So if that's happening to you, Alex, or someone you know, definitely get in touch with us because they're still likely going to have significant entitlements after your last day of work, should that happen. But thank you for your question. I think it's important that people know that there is that ability for companies to provide working notice, but also pay in lieu of notice, or just a payment instead of giving you that working notice, or sometimes a combination of both. Having said that, everyone, I realize we're sort of past our time a little bit today. I will cut it off for today. I thank you very much, as always, for attending. I definitely hope to see some of you or anyone else new next time I appear. As it's noted below, we've got another live going on in Vancouver, 4:30 Pacific, with Darren. So definitely join us for that if you have any questions. And as always, it's been a pleasure, and I'll look forward to seeing all of you very shortly. But thanks again. Do enjoy the rest of your day.